Most Nigerians sign contracts blindly. I'm sorry to say, I've had clients lose their business, run into debt, lose their partnership because they did not understand what they signed. Today, we are going to be discussing something very, very jamming: key contract clauses and their meanings. Hello everyone, welcome again to the Law and High. The Law and High, as we all know, is where law is made simpler and life is made better. I know over time you have been accustomed with all our videos and I hope you are enjoying it. Today we are back again. Remember, I am your host, Folakemi Jagede is my name, and today we are going to be discussing something very, very jamming, and this is what we have titled contract. The key words that you need to understand in contract. Have you ever wondered sometimes where you sign a legal document and you did not even understand the clauses inside that document, whether you have made use of a lawyer or not? This particular video will do you well good. So before you go ahead, can you go ahead and share this video with your friends and colleagues? Notify them that there is another video out by the Law and I. So today, whether you're an entrepreneur, an employee, a freelancer that is always accustomed with contract. Of course, we know contract is very important now as an employee, as a business owner. So relax and take your time to understand each clause that we'll be discussing today and what it means. Let's go right into it. Key contract clauses and their meanings. Most Nigerians sign contracts blindly. I'm sorry to say, I've had clients lose their business, run into debt, lose their partnership because they did not understand what they signed. And today we are going to be looking at different clauses in your contracts that are germane as what they mean to you as a layman or a business owner that don't really have the knowledge of law. The first clause that we are going to be looking at is what I called confidential clause. In a confidential clause, you are going to see a phrase like the parties agree to keep this information confidential under this agreement. In a plain terms, what it means is that all information that will be shared under that contract from the disclosing party to the recipient party will be treated private. That means that you won't disclose it to another person, another third party that is not part of the party to the contract. And the implication of this is this: if you disclose such information, you can be sued, you can run into risk, you are violating the trust that have been bestowed on you. But how can you go about this particular clause if you really understand the meaning from the beginning? You have the opportunity to ask or put into that contract the explanation what qualifies as confidential information. A lot of times I've seen clients that they just, for example, an NDA, you see contract and you look at it like, okay, this is an NDA, but what qualifies as confidential information? Because in the midst of things, a lot of things will be said. So there is a need to qualify those confidential information that need to be treated privately. For example, business trademarks, business secrets, business information, your secret, or because your name is part of information, and you cannot say your name should be treated as confidential. Do you understand? Your address and all those things. But major discussions that will be said during the contractual discussions should be treated as confidential. Let me cite an example. If you are a creative person and you've written a story, the cross of your story, the rhythm of your story, the text of your story, you must qualify it, for example, in an NDA that all these things and the story itself, the substance itself, the scenes, the names used, you know, should be treated as confidential information. So, what I'm saying in the essence, for clause like confidential information should be a plain word that you understand the things that should be treated as confidential. I hope you understand. The next time you see a confidentiality clause, you know what it means. The second clause is non-compete clause. In the legal term, in the contract, you may see something like you may not work with another competitor after 12 months of termination of employment. And in plain terms, what this means is that even when you leave, you cannot work with any other business in the same industry. And you know the risk. This clearly limits your ability to earn even when you leave the job. So the implication of you understanding that particular clause makes you to be able to negotiate. Is it that you negotiate as to the time limit for the non-compete clause to be reduced to like 2 to 3 months, or you enforce compensation upon waiting that long not to work with a competitor? I hope you understand this. Another clause is termination clause. And in legal terms, you are going to see something like either party may terminate the agreement by giving 30 days notice. In plain terms, what it means is that either party can go out of the contract just for heads up within 30 days. And there is a risk if you don't understand that termination clause. You may end up in debt, you may lose your money if it's not properly guided. And if you understand the termination clause, what you can do in such circumstances that anytime termination is said to be done, the liabilities incurred should be paid for. And job already done should be paid for. Sudden termination, which can lead to loss of income, should also be compensated. And by knowing that payment terms will be clearly defined based on termination. I hope you understand this. Another clause is IP clause, meaning intellectual property clause. And in legal terms in your contract, you can see something like all IP created under this contract belongs solely to the company. What this plainly means is that all your work and anything that you create is owned by the company. What is the risk? The risk is that you can't benefit from your work, you can't reuse your work, and also you can't showcase that particular work to people. And if you have the understanding of this clause, then you'll be able to negotiate better and further by putting it in a way like joint ownership, or negotiating it to joint ownership or usage rights for portfolio. You know, I remember the particular time that we engaged a creative in our designs, and they've already signed an NDA, and the creative had to message us as to being able to showcase everything in that particular event for his own portfolio, which we eventually agreed. Because if you don't understand the essence of this IP clause, then you can be sued at the long run if you did not negotiate usage for portfolio, you know, or joint ownership of the IP. So let's talk about indemnity clause. In the contract, you will see something written like you agree to indemnify the company and hold harmless the company from any loss, which simply means that if you are not careful, you will pay for what you did not owe. You know, if anything goes wrong, you pay for it, even if it's not fully your fault. And the risk of that is that you can be paying for something that you did not do. You being able to understand indemnity clause will guide you as to the parameters of what you are indemnifying, of what you are liable to pay for on behalf of the company. So it is very important for you to understand this clause so that you don't pay for what you did not owe. I hope you understand this. So the last but not the least, force majeure clause. This particular clause, you will see something like neither party shall be liable for delays caused by acts beyond their control, which simply means that natural disaster, pandemics may excuse some performances. You being able to understand this clause will help you, or else it will be an open window for different things to happen, and you will be able to limit it to natural disaster or force major issues that are relevant to your industry, to that particular contract, so that it won't be like a copy and paste thing. So when you are able to understand that force major are unforeseeable circumstances that can affect the delivering of that contract as it relates to your industry and the project at hand, you will be able to negotiate better as to the terms of the clause. So today we've discussed key clauses that are relevant in your contract. Remember, a contract is not just a paper, it is a commitment, and if you don't understand it, you are giving someone else the power to interpret it for you. I hope with the little that you have done, you have an handsome understanding of these clauses. Even when you see them in your contract, you know what you are signing. I hope with this clarity, if there is any other clause that you want us to discuss, you can send a message in our videos and we will speak to it. Don't forget to share this with your friends, your family, and your network, that there is another video on the Law and I. The Law and I is where law is made simpler and life is made better. See you in our next video. Thank you.